Ready, start. We shall now examine the decision in Rup Singh on which practically the whole of the arguments on behalf of the claimant were restated, full stop, and examine the facts, comma, it is found that was a case which related to a claim by a third party, full stop. In claims by a third party, comma, there cannot be much doubt that once the liability of the owner is found, comma, the insurance company is liable to the owner to any defense that may be available to it under section 149 in bracket 2 of the Act, full stop, in case where the liability is satisfied by the insurance company in the first instance, comma, it may have recourse to the owner in respect of a claim available in that behalf. It may have recourse to the owner in respect of a claim available in that behalf. Full stop. Rup Singh was a case where the insurance company raised a defense that the owner has permitted the vehicle to be driven by a driver who really had no license and the driving license produced by him was a fake one. Full stop. Their lordship discussed the position and held ultimately that a defense under section 149 in bracket 2 of the Act was available to be insurer when a claim is filed either under section 1336A or under section 166 of the Act, full stop. The breach of a policy condition has to be proved to have been committed by the insurance for avoiding liability by the insurer, full stop. Mere absence of production of fake or invalid driving license or disqualification of the driver for driving at the relevant time, comma, are not in themselves defendants available to the insurer against either the insured or the third party, full stop. The insurance company, to avoid liability, comma, must not only establish the available defense raised in the producing concerned, but must also establish breach on the part of the owner of the vehicle, for which the burden of proof will rest with the insurance company. Full stop. Para. It becomes very clear from a perusal of the above mentioned case law of this code that the insurance company, in order to avoid liability, must not only establish the defense claimed in the proceeding concerned, comma, but also establish breach on the part of the owner insured of the vehicle, for which the burden of proof will rest with the insurance company. Full stop. In the case, the respondent company has not produced any evidence on the record to prove that the accident occurred on account of the overloading of passengers in the goods carrying vehicle. Full stop. Further, comma, as has been held in the case of B.N. Swarup, that for the insurer to avoid his liability, comma, the breach of the policy must be so fundamental in nature that it brings the contract to an end. Full stop. In the instance case, comma, it is undisputed that the accident was in fact caused on account of the rash and negligent driving of the offending vehicle by its driver, comma, against whom a criminal case wide FIR number 66 of 2010 was registered for the offence referred to supra under the provision of the IPC. Full stop.